A very warm good morning to all of you. I formally welcome you all. I hope you are doing well in these trying times. Today, I intend to deliberate on certain important aspects that is relating to the normative framework for media freedom, media culture, incidental issues, or rather, I should say, beyond the normative de-westernization, or in a socio-political milieu of decolonization, we are going to understand the reimagining of the global South within the framework of media freedom. We have to examine media culture from the South or global South perspectives. We are also going to determine, examine, and critically appreciate the devices of free speech and access to information under international law, legal institutional limitation which have been contemplated over the years within the context of the South Asian region. We have to understand freedom of press, speech, and expression, and its various manifestations, implications, aberrations, and what exactly have been the consequences of freedom of speech and expression under international law in various geopolitical entities and various national jurisdictions. We have to understand the response of the corporate and commercial speech. We have to understand how various media citadels have become subservient to the governmental agencies. We have to understand the various types of the defamatory material within the national jurisdictions of SAARC nation states and beyond SAARC nation states. So this is going to be our brief. And for that, my dear friends, I invite your attention how you perceive in your respective jurisdictions the idea of fundamental freedom which is available to media houses, and what exactly has been the response when we are talking of constitutional obligations of these media houses that has to be taken into consideration. When we are talking of the normative framework means that there are certain important fundamental guarantees, fundamental civil liberties, fundamental human freedoms, which are exclusively based on human dignity, probity, integrity, individualism, liberalism, pluralism, and particularly, we should not forget the democracy of diversity, idea of cosmopolitanism, and the most working atmosphere that is generated by invoking the fundamental value of the multiculturalism in many geopolitical entities. Collectively speaking, these fundamental values, without any stratification of these values into European values, American values, or Asian values, collectively speaking, my dear friends, these are the values which ultimately established a grand notion of international standards on freedom of speech and expression. Whether we are living in Africa, whether we are living in South Asia, these are the fundamental responsibilities with which we try to understand that there are certain international standards, certain international understandings, wherefrom there is no possibility of any kind of deviation or ignorance. Under all circumstances, these facets must be taken into consideration, because everyone has the right to freedom of opinion and expression, and this right, my dear friends, include freedom to hold opinions without interference, without any kind of extrapolation or intrapolation, and at the same time, each and every individual has been empowered and well equipped under the respective constitutions to seek, receive, and impart information, ideas through any media, regardless of geopolitical demarcations. Without any kind of frontiers at international level, it has become the responsibility of each and every individual to understand that this is the idea of a very, very substantive character, very normative character, and within which we try to operate entire our normative understandings. And when I am talking of the international norms, when I am talking of the international standards, when we are talking of the international understandings, it means there are international frameworks. Certain specific articles have been designated just to empower the freedom of speech and expressions. The media houses have to adhere to these fundamental principles of an international character. So this is the responsibility as a civil society, as in our individual capacity, as a legal institutional harbingers, as a institutional manifestation in each and every geopolitical entity. It is our collective responsibility to understand this particular right in the form of what we call of international understandings. Let me give certain important examples to understand further what exactly has been the entire understanding of a normative what we call footing, or the normative basis, where we are talking of the normative framework. Charity begins at home, my dear friends, and that is why we cannot forget constitutions. Constitutions are important. No constitution can claim that it does not have any kind of provision with regard to the freedom of speech and expression. And two important aspects have been incorporated in each and every constitution. Number one, there are certain important instrumental arguments. There are certain important instrumental rights relating to the freedom of speech and expression, or the media freedom. At the same time, there are certain important rights which should be considered as inherent right of the freedom of media or freedom of press. There are certain intrinsic rights of each and every media house that carrying out this particular obligation, which is known as a responsibility towards the ordinary citizens, and that is generally stamped and established by invoking freedom of press or freedom of speech and expression. So indigeneity must also be taken into consideration. Suppose Article 19 of the International Covenant on Civil and Political Rights, that is ICCPR. Article 19, my dear friends, has ultimately established, in addition to the Universal Declaration of Human Rights, so again, Article 19 of the Universal Declaration of Human Rights, which is of a very normative character, but it has been given its entire, idea of normativity has been expanded further, again, under the, rubrics of the International Covenant on Civil and Political Rights, under Article 19, that everyone shall have the right to hold opinion without any kind of, intervention or interference. Everyone shall have the right to freedom of expression. And my dear friends, this right includes freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally or in writing or in print or in the form of art or through any other media of his or her choice. That is the expansion. That sort of expansionization has been attributed to this particular idea of free speech, free press. My dear friends, the exercise of these rights provided and that has been, provided, particularly in paragraph, 3 of Article, 19, and that carries with it special duties and responsibilities. Therefore, this particular right is subject to certain restrictions, but there shall only be such as are provided by law and that are, necessary, particularly in respect of the right or reputation of others. A reasonable, restrictions have been contemplated for the protection of the national security or public order or of public, health and morals. But who is going to interpret Article 19, or for that matter, the various constitutional, provisions on each and every, constitution? Suppose take the example of Article 19 of the Constitution of India. Article 19, subclause 1A, that also undertakes this particular, idea, freedom of speech and expression, and that includes media freedom as well, or the freedom of what you call media, and that also envisions the idea of free press. So, public order, public health, public morality. So it is a question of what we call objectivity. But it has been seen, my dear friends, if you take into account the recent judicial responses as well as the institutional or legal-institutional responses, then this idea and its critical, appreciation has attained the status of what we call of one of the most important, preemptive norms of international law to a very limited extent. But we should not forget that the Article 19 of the International Covenant on Civil and Political Rights has established its efficacy, and it has also been incorporated in various what we call constitutions. Whether the Constitution of the South Africa is there, whether the Constitution of Pakistan or India is there, this article has got some kind of expression, some kind of a constitutional approbation. Again, my dear friends, another important what we call trajectory, as a part of the international trajectory of international obligations with regard to the approbation of free press is also expressed, my dear friends, under African Charter on Human and People's Rights. Article 9 of the African Charter on Human and People's Rights becomes very, very important. The very subclause of Article 9, my dear friends, that every individual shall have the right to receive information. And I would subsequently be, coming to that particular right as well, where we are going to have this particular right and how international law ultimately appreciated this particular, contention, right to receive information, right to access to information, which is generally what we call, found in the domain or within the jurisdiction of the, governments or the national, governments. And subclause 2 of Article 9 of the African Charter on Human and People's Rights also takes into account that every individual shall have the right to express and disseminate his or her opinion within the framework of, law. So therefore, it is very, very important, my dear friends, that we should not, forget how this particular, right, that how it has been incorporated under Article 9. Then we should not forget, my dear friends, the resolution 169 on repealing criminal defamation law in Africa by the African Commission on Human and People's Rights, and that has been abolished, my dear friends, in 2010. Because that resolution underlines that the criminal defamation laws constitute a serious interference with freedom of expression and impairs, obstructs the role of the media as a watchdog, preventing journalists and media practitioners to practice their profession without fear or in good faith. At the same time, my dear friends, resolution 169 of the African Commission on Human Rights, that is also commending state parties to the, or rather I should say that ordered state parties to the African Charter. I mean the states parties that do not have or have completely repealed insult and criminal defamation laws. And it calls upon the states, my dear friends, to repeal criminal defamation laws or insult laws which impede freedom of speech and to adhere to the provisions of the freedom of speech and expression which have been articulated in the African Charter, the Declaration, and other regional and international instruments. And this resolution also calls, my dear friends from the state parties, to refrain from imposing general restrictions that are in violation of the right to freedom of speech and expression, or the free press, what we call, mechanisms. Another important, regional arrangement that comes to my mind on earlier occasions also, I have, cited this, and again, I am bringing it for your kind, perusal, that should not be forgotten, and that is European Convention for the Protection of Human Rights and Fundamental Freedoms. Article 10 of the European Convention becomes very much germane to our ongoing deliberations for understanding the normativity of this entire normative and substantive framework for the freedom of speech, or the free press, or the freedom of speech and expression, in particularly under international law, under regional what we call, mechanisms, and under other important, bodies. My dear friends, Article 10 of the European Convention on Human Rights stipulates that everyone has the right to freedom of expression. And this right includes, my dear friends, freedom to hold opinions, and that is the pervading line of argument under international law, under African level, at what we call, European level. At the same time, you will also find the similar and identical what we call, semantics have also been employed, like to receive and impart information, ideas without interference by public authority, and regardless of their any kind of a, national boundaries or frontiers. Therefore, this particular article, I mean the Article 10 of the European Convention on Human Rights, shall not prevent states from requiring the licensing of broadcasting, television, or cinema, what we call, enterprises or cinematic undertakings. Exercise of these, freedoms under Article, 10, since it carries with the duties and responsibilities, may be subject to such formalities, conditions, restrictions, riders, penalties, observations, as are prescribed under the law or are necessary in a democratic society. And at the same time, my dear friends, these conditions must also be in the interest of the national security, territorial integrity, or the public safety, for the prevention of disorder or crime, or for the protection of health or morals, and for the protection of reputation and rights of what we call of others, or for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judicial establishment or highest judicial citadel in any geopolitical entity. That is the mandate of Article 10 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. Then we should not forget, my dear friends, the American Convention on Human Rights. Article 13 again becomes very, very important of the American Convention on Human Rights that should also be taken into consideration. It's a very, very long, article that is having as many as 5 important subclauses. But for our understanding, it is axiomatic from the very first clause that everyone has the right to freedom of thought and expression. And this right again includes freedom to seek, receive, and impart information and ideas of all kinds. That is the mandate. Cumulatively speaking, whatever the articles, I mean the mandate we have understood from Article 10, from Article 10 of the European Convention on Human Rights, Article 9 of the African Charter on Human and People's Rights, and other important what we call Article 19 of the ICCPR and Article again 19 of the Universal Declaration of Human Rights have been given some kind of engrafting, a verbatim engrafting that is reflected under Article 13 of the American Convention on Human Rights. But if you take into account a certain specific subclause of Article 13 of the American Convention of Human Rights, particularly relating to any propaganda of war or any advocacy for national, racial, or religious hatred that constitute incitements to lawless violence or to any other what we call similar action against any person or group of person or any grounds, including those of race, color, religion, language, or national what we call origin, shall be considered as offenses under the law, or that is punishable by law. That is the beauty of this particular Article 13, because United States of America claims itself to be a multicultural society, and they generally celebrate what we call, diversity. I'm not talking of the recent what we call, attacks on Indians in United States of America, as well as some attacks on, Asians, particularly on South Asians in United States of America and Canada. That should not be the, basis of our, understanding or evaluation. But what is important so far, the normative framework is concerned, this is the, idea that is reflected in their, commitment. But at the same time, my dear friends, so far the South Asia is concerned, or so far the Southeast Asia is concerned, particularly the Asian, what we call, human rights declaration, we should not forget. But at the same time, the South Asian declaration on migratory movements and other important, fundamental understandings which are there in South Asia. I mean, I'm talking of specific provisions of the constitution, so of all the constitutions of South Asia, where we find the freedom of speech and expression, an idea and concept of the free press that should not be, forgotten. But if you take into account the Asian Declaration, then Asian Declaration is of vital importance, my dear friends, because there is no established, well-crafted regional human rights body for Asia. And that is the travesty of human rights in our part of the world, and that is, South Asia, or beyond, South Asia, or Asia as a continent, as a whole, rather, I should say. Nevertheless, my dear friends, 10 countries of the Association of Southeast Asian Nations formally established the Asian Intergovernmental Commission on Human Rights. And this has been established, my dear friends, I think in the year 2009, 21st century. It was the result of the 15th Asian Summit. And this group also adopted a human rights, declaration which guarantees freedom of expression as fundamental, what we call, understandings. In this declaration, if you take into account Article 23 of Asian, Declaration, you will find that every person has the right to freedom of opinion and expression, including freedom to hold opinions. It has also been taken, my dear friends, from the rest of the what we call, rights which have been incorporated in other what we call, regions of the world. So this has been the most fundamental aspect of entire normative understanding. And this has also been, made available under Article 9, my dear friends, on African Charter on Human and People's Rights. And it has been further given way, and that has also got some kind of a solidification in this, soft law, and that is the Asian Declaration on Freedom of Speech and Expression. Therefore, my dear friends, it is important to understand at this stage that access to information and respect for privacy protections constitute the most important part of this normative, understanding or normative framework. Because access to information is a key element of media freedom and a defining prerequisite for journalists to perform their functions in a democratic political setup. It is a key, my dear friends, for transparency. It is a key, my dear friends, for development. And it is a key to understand the fundamental human freedoms in any geopolitical environment. Access to information. And that is why we have been blessed, my dear friends, with a lot of what we call, legislations on this particular point. If you take into account the 2030 Agenda for Sustainable Development that was adopted by the United Nations General Assembly in September 2015, that also includes goal number 16, subclause 10, and that ensures, my dear friends, the public access to information and protective fundamental freedoms in accordance with the national legislation and international agreements. It is one of the most important goals when we are talking of access to information and privacy. I mean, the amount of protection which is generally available to what we call, human privacy or individual privacy or community, privacy. So this should not be forgotten. But at the same time, my dear friends, we should take into account the number of countries that adopt and implement what we call constitutional, statutory, or policy what we call guarantee for public access to information. Whether it is South Asia, whether it is the European nation states, whether it is the Latin American countries, particularly Brazil, or the central what we call republics, particularly Kyrgyzstan. So this should be taken into considerations. They have really given a very, very important, very sustainable what we call treatment. So far, this commitment is concerned under what we call international law, and therefore that becomes very, very important, my dear friends. And we must try to understand that what kind of a idea of right to information under international what we call law, under international human rights law, is available to the people at large. Just a moment, please. I'm sorry. Dear friends, access, or I should say, that existence of a right of access to governmental information or the information in possession of government is increasingly accepted around the world, both at the domestic level as well as at global or international levels. At the domestic level, my dear friends, a right to information is to be found in a growing number of constitutions. And since the early 90s, what we have been witnessing, that there has been a huge what we call upsurge, I should say, regarding the growing number of what we call of claimants, growing number of states adopting freedom of information laws. Internationally speaking, my dear friends, the existence of the right of access to information is frequently articulated in international human rights instruments. The first ever international convention on access to information, my dear friends, has been adopted, and human rights enforcement bodies, both regional and global, have interpreted existing human rights treaties as fostering a right to information with a range of what we call of context and contents. Right to information has been most commonly recognized by international human rights treaty bodies as it comes, my dear friends, within the scope of the right to freedom of expression. Those such bodies have, on occasions, based their recognition of a right to information on the enjoyment of other important incidental, ancillary, and vicarious rights. For example, right to respect for private life, the right to a fair trial, the right to life, compendium of socio-economic rights, right to participate in public affairs. And my dear friends, one of the themes that gyrates around all such, rights, and that comes out very conspicuously and makes its existence very much, visible, and that is right to access to government information. And this is a right which cannot be underestimated, my dear friends. Therefore, the rights are morally, I should say, derivative from other more fundamental values, as I have already pointed out, without any kind of, categorizations. The good of what you call, happiness. I can give you a number of examples. You are well acquainted with these kinds of, examples. When we are, talking of instrumental, what we call, rights, inherent, rights, then definitely, my dear friends, self-realization, knowledge, freedom, evils of, misery, ignorance, repression, cruelty, deprivation, all these kinds of what we call of, menaces, which really makes human existence miserable. On this particular, footing, my dear friends, therefore, rights are of vital importance as a means of fostering those, goods and preventing those evils, but they are at the same time, my dear friends, are not what we call, themselves fundamental. That is why I am using the word instrumentalism. Instrumentalism, my dear friends, is associated with a utilitarian approach to rights. Utilitarian, what we call, perspective on rights, which focuses on maximizing overall happiness, and which has been, criticized as paying insufficient attention, my dear friends, to the idea of individual and individual rights, as well as the vision of individualism. Therefore, it is our fundamental responsibility, and this reminds me of a very, very important, jurist. Rawls, for example, was of the view that the utilitarian does not take seriously the distinction between persons. Therefore, opponents of instrumental, or the view that is exclusively based on this particular argument or reason, which I called instrumentalism of rights, similarly argued, my dear friends, that it cannot plausibly account for the strength of individual rights. Therefore, it becomes very, very relevant in our understandings. Because, my dear friends, when we are talking of the right to information under international human rights law, then these approaches which you have studied in your jurisprudence classes, international law classes, and international human rights law classes must be invoked in understanding this particular right. We have to locate the right to, information, right to access to information in the possession of the, governmental authorities and the governmental agencies. Until the Council of Europe adopted, my dear friends, the Convention on Access to Official Documents in 2009. This is one of the most important, convention in the present day, circumstances, and this is the only convention, my dear friends, which I have also made a reference earlier in my, submissions. Though it has not been completely operationalized. Because as per the, requirement under one of the, articles of this, European Convention on Access to Official Documents that was adopted in 2009 has been initially ratified by only 6 national, parties. But the full operationalization, the full implementation of this particular European Convention can only be achieved after the ratification, if it is ratified by more than 10 countries as per the mandate of the convention per se. But as of now, only the 8 nation states have ratified from Europe. But normatively speaking, my dear friends, this is the only convention which should be what we call, taken as the most important convention in any region. We do not find such kind of a mechanism or such kind of a constitutional as well as the international law induced approbation on the part of the any region, and it is the Europe, and Europe has the distinction to have this kind of a novel what you call convention on access to official documents in 2009. Therefore, my dear friends, in 2009, international human rights documents did not afford explicit protection to the right to information, while the recognition of the right to information in international human rights law was also slow to evolve. International human rights bodies such as the UN Human Rights Committee, the European Court of Human Rights, Inter-American Court of Human Rights, and the European Committee on Social Rights have today accepted the existence of a right to information in certain important plausible circumstances. And this is a right which cannot be taken away. This has invariably, my dear friends, occurred in the context of the securing of other rights, including both civil and political and economic and social rights. Each of these foundations for the right to information or right to access to information has to be considered with a liberal interpretation of those very provisions which have been what we call made available in various international human rights law instruments. Because we have to build, my dear friends, we have to evolve, we have to enrich and foster current status of the right to information under international what we call human rights law, and that should be taken as fundamental duty of all the what we call national alliances and national what we call bodies. Therefore, we should try to understand what is right to freedom of expression. What do we mean by right to freedom of expression? Anybody? Yes, please. I am not asking an intricate question. Anybody can, come out with his or her, observations. What is your understanding of the right to freedom of expression? Yeah, Mr. Sagar. Yes.
Sir, right to freedom of speech and expression means where one can clearly and very precisely give his thoughts, his
Yes.
views, and he's free to speak about it. He should not keep it with himself. The state should not. It is basically where state should not suppress or create a scenario where the person cannot express his feelings and expression, his opinions.
Right. Yes, Miss Sumaya Islam, may I request you?
Yes, so in my opinion, if we ask anyone to express his like to exercise his right of freedom of expression, I would say he has the right to say anything, even if it is a criticism of government, even if it is a comment about an influential person. He should not be afraid of, or he should not be be dominated by someone. So that is, in my opinion, the freedom of expression is.
Yes, Miss Rasool.
Sir, the freedom of speech is basically the freedom of an individual to articulate his opinions, his ideas, and it also includes the right to seek information, to impart information without any censorship. But states, due to the national security, it always put restrictions on this the freedom, and also I think it intrinsically includes that where my right of freedom of speech ends, the right of freedom of speech of other person starts. That's it, sir.
Yeah, good. Very good. Anybody else? Mr. Maharaju.
Sir, good morning, sir.
Good morning, brother.
I thought to add that one point that it also includes right to receive information.
Exactly, very true, very true.
And so that Vasaf mentioned. So, and also it is very important for a democratic country that freedom of speech and expression you can find in every constitution that there is a provision. So it's a universal, aspiration.
Yes, absolutely. I also believe in this line of argument. But may I ask you further? And that is, since you are a very, very committed person, and it is axiomatic, and this is my consequent inference, I should say, that when I see, my dear friends, your DP, suppose right now I am seeing on my computer screen, on my laptop screen, a DP, that is the display picture of Mr. Periyar, Honorable Periyar, I should say. Is it the picture of?
Yes, sir. Yes.
Yes. So, what was the Periyar's view on freedom of speech and expression? Can you cite some of the important examples? Because we understand the views of the Dr. B.R. Ambedkar, we understand the views of the Bangbandhu from Bangladesh, Bangabandhu, the father of nation, late Mr. Mujibur Rahman of Bangladesh. We understand so far the freedom of speech and expression is concerned as per the forefathers and the drafters of the Constitution of Islamic Republic of Pakistan, particularly Barrister Jinnah, the father of nation, I mean Mr. Muhammad Ali Jinnah. So we understand his views. So there have been a lot of personalities, or rather in one word, without any kind of a demarcation, without any kind of a categorization, there have been certain important towering personalities of the Indian National Congress when it was founded in 1885. And the people like Aine Khan and Muhammad Ali Jinnah and other important personalities, they had been the part of this organization that was established to seek the freedom of entire United India from the foreign clutches. So what is your view? How the personalities like Periyar came out with the idea of the access to information? Because when we are talking of the rights of Dalits, when we are talking of the rights of minorities, when we are talking of the idea of a welfare state, when we are talking of a state and its resources, equitable distribution, enjoyment of fundamental rights, freedom of speech and expression, freedom of free trade and intercourse, then it becomes very, very important that we must have the right to access to information, and that is generally always in the possession of government. So can you give me some kind of a ideological understandings on the basis or with regard to the right to access to information? Because this is the key element when we are talking of the freedom of media or the free press. Because it is an instrumental right, it is also an inherent right. So the instruments we are having, like the constitutions, how the constitutions have been further what we call appropriated and liberalized by supplying lot of what we call of debates, and ultimately we were able to reduce those debates in the form of certain important rights. In case of the Constitution of India, it is Article 19. So can you throw some light on these observations?
Sir, I think this notification, this poster you received, I think, this casteism in capitalist society, AAMSP. And where during this lecture, Justice Chantru mentioned that when one person asked about what is the contribution of South India to the this casteist against the casteist, and he mentioned that Periyar, and thanks to Periyar. So uh, when one speaks of anti-caste movements, we cannot forget the contribution of Periyar to this. And so he is a protagonist of rationalist and anti-caste, even God. He is against atheist. So on his view on freedom of speech and expression, I don't know, but I try to next lecture I will say it.
Yes, Miss Karishma.
Yes, sir. Sir, I also do not know to the extent to the views of Perrier, but by the contributions of Maharajan, I can like infer that was also uh, he also believed in freedom of speech and expression. Uh, Given the fact that he is a rationalist, so that brings to my mind that he uh, he would uh, sorry he would be a one who would what I cannot find the word, would like bring forward the idea of like bringing freedom of speech and expression, and throwing and exchanging of views and opinions of others as well as his.
Yeah. My recommendation would be that we please try to understand different personalities, different liberation, what we call movements have taken place in South Asia. Different caste movements, different peasant movements, different student movements have already taken place in South Asia, and there have been certain important takeaways on free press, free media, freedom of speech and expression. So please collect them and try to what you call reflect upon them. This is my recommendation, because then only we would be in a better position to understand the evolution of the freedom of speech and expression in South Asia. Though separately I will deliver a full-fledged talk on this particular aspect as a part of our engagement. But my dear friends, when we are talking of right to freedom of expression, perhaps the most broadly based of the rights that have been relied upon as the foundation for a right to information is the right to freedom of expression. Every international human rights instrument protects, my dear friends, this fundamental right. Traditionally speaking, contention of the right to freedom of expression had been on the provider of information. And this reminds me of the contributions of a Sri Lankan, a jurist, a judge from Sri Lanka. I am talking of the Veera Mantri. Veera Mantri expounded, my dear friends, that libertarian or liberalist, what you call, theories, generally and invariably, I should say, concentrate on the rights of the speaker. The right to information, therefore, on the other hand, has a its core the potential recipient of that very information. The foundation, my dear friends, therefore, of the argument for including a right to information under the umbrella of freedom of expression is that access to information is a precondition of the full exercise of the right to freedom of expression. And this should never be forgotten. Because critically speaking, my dear friends, such information includes not only that which the provider wishes to furnish to the recipient, my dear friends, but also information that others, such as the government, do not wish to make available to him or her. The right to information, therefore, can be said to be instrumental to the enjoyment of the right to freedom of expression, or as expressed more, what we call, vividly, colorfully, and beautifully, my dear friends, by Judge Bell of the Victorian Civil and Administrative Tribunal, in one of the finest, what we call, judgment, and that judgment you are not going to forget because of the name of the judgment. It is, XYZ versus Victoria Police, where the freedom of information has been contested, and that has been what we call, provided that it is in the blood, my dear friends, which runs in the veins of the freedom of expression. That is the, argument. That kind of a, equation has been provided by Justice Bell in this particular decision, XYZ versus Victorian Police. It has been equated to somewhat, some kind of a, DNA. This DNA is of vital importance when we are, talking of the freedom of information. Then the freedom of information, there is a precondition, there is a prerequisite, and that prerequisite is known as, my dear friends, as right to access to information. Because the freedom of expression and freedom of information have long been linked in international human rights engagements and documentation. This reminds me of a very, very important report at this stage, which I would like to share with all of you, my dear friends. UN special reporters have submitted a report in the year, my dear friends, I think in 1998 or 1994. So if you take into account this UN special reporters on freedom of opinion and freedom of expression, they have supported the recognition of a right to freedom of information within the framework of the right to freedom of expression in the International Covenant on Civil and Political Rights, that is popularly known as the ICCPR under Article 19. This report, my dear friends, further referred to the right to seek, receive, and impart information as per the mandate of Article 19 of the ICCPR. And it has been imposing a positive obligation on the state to ensure access to information, particularly with regard to information that is possessed by the governments. If you take into account the subsequent reports, which are equally available in the public domain, my dear friends, you will find that the view which has been expressed by the UN special reporter under Article 19 encompasses a right of access to information. For example, in 2005 report, you can consult of the special reporter, where it has been agreed upon, where it has been endorsed, where it has been approbated that the international standards establish only a general right to freedom of information, the right of access to information, especially information that is possessed or held by the public bodies or the governmental agencies, is easily deduced from the expression to see and to receive, as my friend, you have also pointed out, Mr. Maharajan. Therefore, whatever the information as it has been espoused, it has been contained under Article 19 of the ICCPR, or Article 19 of the Universal Declaration of Human Rights, and other important regional instruments, becomes very much relevant. Again, in 2004, my dear friends, special reporter, along with the special reporter on freedom of expression of the Organization of American States and the Organization for the Security and Cooperation in Europe, issued a joint declaration, and this joint declaration, they have recognized the right, access right, I should say, as a fundamental human right based on the principle of maximum disclosure. And in 2010, my dear friends, UNESCO, another important what we call subsidiary organ of the United Nations organizations, ultimately stamped World Press Freedom Day in 2010 by issuing the Brisbane Declaration. And this Brisbane Declaration is of vital importance, which called on national governments who had not already adopted access to information laws to do so, and particularly based on the international standards and the principle of maximum disclosure. So Brisbane Declaration has further what we call accommodated. Again, my dear friends, if after what we call 2004, it is 2011. In a highly significant development, I should say, United Nations Human Rights Committee published a new journal comment on Article 19 of the ICCPR, which is in contrast to its previous what we call expressions. Ultimately acknowledge that Article 19 embraces a general right of access to information that is found in the possession of the public bodies or the governmental agencies. The general comment, my dear friends, ultimately stipulated in arriving at this position that Article 19, taken together with Article 25 of the international what we call Covenant on Civil and Political Rights, it is again, my dear friends, takes into account the right to take part in public affairs that had previously been interpreted by the committee as including the right of the media to access to information on public affairs and the right of the general public to receive media what we call outlet. The Human Rights Committee further noted, my dear friends, that elements of the right of access to information were addressed elsewhere in or under what we call in addition to Article 19, in addition to what we call Article 25. Other important articles are equally important, equally relevant so far International Covenant on Civil and Political Rights is concerned, particularly relating to the right to access to information. It was subsequently therefore pointed out, my dear friends, that Journal Comment number 16 regarding Article 17 of the ICCPR, the right to privacy, addresses the issue of access to an amendment of the personal data relating to individuals, while Journal Comment 32 regarding Article 14 of the ICCPR, whereunder the right to a fair trial, sets out the various what we call claims, entitlements, right, and particularly the entitlements to information that are held by those accused of a criminal what we call offense that should not be forgotten on this particular point. Therefore, my dear friends, committee, the Human Rights Committee also made references to the fact that Article 10 of the European Convention, as well as what we call of ICCPR, the right to be treated with humanity and dignity, had been interpreted by the committee as preserving the right of prisoners to access their medical what we call records, medical what we call requirements, and ultimately the Human Rights Committee ultimately jot down, my dear friends, that the Journal Comment 31 on the nature of the general legal obligation imposed on the parties to the covenant, or the parties which have become party to 66 Covenant on Civil and Political Rights, should, pursuant to Article 2 of the Covenant, be in receipt of information regarding their covenant rights in journal. My dear friends, therefore, the Journal Comment 34 becomes very, very important, and this Journal Comment has also attained the status of what we call the legal implications, and therefore Journal Comment number 34 fleshes out the requirements necessary to give effect to the right of information or right to access to information protected under Article 19 of the ICCPR. Parties to the covenant therefore should both proactively publish government information of the public interest and enact the necessary procedures whereby one may gain access to information, such as by means of freedom of information legislation. Interestingly, my dear friends, at this stage I must say that the Journal Comment goes into a degree of what we call of details in terms of the contents, in terms of legislation, where while referring to, I should say, in particular to the need to make provisions for the timely what we call processing of request for information, for giving of reasons for refusal of access to information, and for law putting in place of an appeal system or other kind of alternative mechanisms. It also states, my dear friends, that fees for request for information should not be as such, or should not be such as to what we call constitute an unreasonable impediment to access to information. But over the years, what we have been witnessing in many geopolitical entities, that the exorbitant amount of fee is being contemplated under the law, and increasing the fees, my dear friends, has become another important obstruction to the access to information that is invariably, under all circumstances, always found in the possession of what we call of the governmental bodies and the governmental agencies. Nevertheless, my dear friends, whatever may be the developments which have been encapsulating the right to information, the international human rights courts, international human rights monitoring bodies had for many years, my dear friends, slow to interpret right to freedom of expression as encompassing a right to information. More recent developments, if you take into account, my dear friends, indicate a willingness to move towards the recognition of the right, however, at least in a specific context. This reminds me of a very, very important what we call, view that has been expressed by the United Nations Human Rights Committee in 1999, at least in a specific context, that Article 19 of ICCPR read together with Article 25. Article 25 is relating to take part in the conduct of the public affairs, implies that citizens, in particular through the media, shall have wide access to information and the opportunity to disseminate information and opinions about the engagements, activities, as well as involvements of the elected bodies and members. And this case, my dear friends, revolved around the issue of access by the applicant journalists to press facilities in the in many jurisdictions. Particularly, this reminds me of the Canadian Parliament, where we find that the issue access to information per se has been what we call facilitated in all its what we call manifestations. 2009, my dear friends, admissibility decision by the Human Rights Committee in SB versus Kyrgyzstan becomes very, very important on this particular point, because this Central Asian Republic, or the newly independent republic from after the disintegration of the USSR in 1991, if you take into account this particular case, it was less encouraging in terms of the recognition of a right to information. The applicant in this particular case, my dear friend, was a human rights activist who had requested information concerning the pronouncing of the death sentences in Kyrgyzstan. Therefore, the Human Rights Committee noted that the applicant had not explained why exactly he personally needed or required the information in question, and that he, at the same time, had merely contended that it was a matter of the public interest. Therefore, the Human Rights Committee went on to hold that in the light of these circumstances and in the absence of any other pertinent information, the complaint constituted an actio polaris, what we call, and that was therefore inadmissible. So ultimately, he has not been what we call, given any sort of information, and that has created a lot of what we call controversies. My dear friends, again, I can cite another important development in 2011. The pendulum ultimately swung back and again in favor of the right to information. And with the decision of the Human Rights Committee in another important what we call case, again emanating from Kyrgyzstan, and that is, I am forgetting the name of that very decision, but it is generally and very popularly known as, because in this particular decision, some of the important diagnosis that was conducted and ultimately found in SB versus Kyrgyzstan was also what we call some kind of platitude, and it is Toktanov versus Kyrgyzstan. I think I'm not able to pronounce the first name of the case, but it is something Toktanov or something. So the facts of which what we call ultimately mirror, I mean those of SB versus Kyrgyzstan, and the Human Rights Committee found that the applicants' Article 19 rights had been violated by the refusal of the Kyrgyzstan authorities to provide him with access to statistics on the imposition of the death sentences in that very jurisdiction. On the issue of admissibility, my dear friends, the Human Rights Committee noted that the information sought had been deemed to be information of the public interest in a number of the UN documents, each of which was either signed or accepted by Kyrgyzstan. The Human Rights Committee went on to say that the reference to the right to seek and receive information contained in Article 19, subclause 2 of the ICCPR included the right to other important what we call facets, and that ultimately resulted in the refusal of the authorities to make the information available to him, and that the application was therefore found to be inadmissible or unadmissible, whatever you may call. But this has ultimately established a very sorry state of affairs where the right to information has always been what we call sought, and that has been appreciated under the rubrics of what we call of the juristic writings. My dear friends, it is equally important to understand at this stage that Human Rights Committee ultimately concluded that the state party had an obligation either to provide the author with the required information or to justify any restrictions of the right to receive state-held information under Article 19, subclause 3 of the covenant, and that is ICCPR. Human Rights Committee therefore found that none of the restrictions permitted under Article 19 subclause 3 applied, and so the Kyrgyzstan was found to be in breach of its international what we call human rights law obligations under this particular article, and that is Article 19 of the ICCPR. But if you take a journey at the regional level, my dear friends, what has been the circumstances? What is the situation at regional level when we are talking of right to access to information? My dear friends, at regional level, an influential milestone in the international development of the right to or right of access to information ultimately happened in the year 2006, when the Inter-American Court of Human Rights handed down its decision in Claude Reyes versus Chile. This is again a very, very important decision in the history of what we call of the media freedom. My dear friends, Claude case or Claude Reyes case emanated in a request for access to information relating to a deforestation project submitted to the Chilean Committee on Foreign Investment by an environmental group. Committee provided the applicant with some of the requested information, but did not adopt any written decision justifying its refusal to disclose the remaining information. The failure of the committee to disclose all of the requested information and the lack of the written response from the committee were unsuccessfully challenged by the applicant before the domestic courts, which deemed his complaints inadmissible, as it has always been the case in many of the similar and identical situations. The applicant made a complaint under the American Convention on Human Rights, arguing including that the failure of the Committee on Foreign Investment to disclose all the information he had requested amounted to a violation of Article 13 of the American Convention on Human Rights, which, my dear friends, protects freedom of expression. If you take into account the Inter-American Court of Human Rights diagnosis that by expressing or expressly stipulating the right to seek and receive information under Article 13 of the Inter-American Convention on Human Rights, and that protects the right of all the individuals to request access to state-held information, with the exceptions permitted by the restrictions established in convention. Therefore, or consequently speaking, this article protects the right of the individual to receive such information and the positive obligation of the state to provide it. That has not been properly appreciated. A later decision of the court in another what we call the case, and that is the Gomes what we call Gomes versus Brazil, extended the scope of the right to information of expression to contribute to the recognition of the right to truth about gross human rights violations. The case, this particular case, that is the Gomes versus Brazil, concerned and ultimately impugned a challenge to amnesty laws prohibiting prosecutions for torture and killing committed during the military dictatorship in Brazil in the 70s. The court held the laws was incompatible with the American Convention and void of any kind of legal effects. The right to truth, my dear friends, about gross human rights violations was ultimately propounded by the court to be connected to the right to seek and receive information as it has been enshrined under Article 13 of the American Convention on Human Rights. By denying and delaying access by the victims, relatives to relevant army archives and other information, Brazil was held to have violated their Article 13 right to information when read together with the Articles 8 and under Article 8 of the Inter-American Commission on Human Rights. Article 8, my dear friends, stipulates a duty to investigate grave violations of human rights, and it has to be read with Article 25, and that takes into account, my dear friends, the judicial protection of rights. Therefore, the path to recognition by the European Court of Human Rights of a right to information as part of the right to freedom of expression has long been tortuous, tedious, and troublesome, I should say. And some of the earlier decisions of the supervisory bodies of the European Convention on Human Rights had been quite expensive in their approach to interpreting the scope of the right to freedom of expression. And again, I can cite at this stage, my dear friends, in 1979, in X versus Federal Republic of Germany, for example, the European Commission on Human Rights, my dear friends, ultimately found that the context in which the right to receive information is generally what we call mentioned. It envisages, first of all, access to general sources of information. The right to receive information may, under certain circumstances, include a right of access by the interested what we call persons to documents which, although not generally accessible, are of particular importance. And therefore, in the same year, my dear friends, in Sunday Times versus United Kingdom, a case which concerned a challenge to the granting of an injunction by the British courts against the publication of an article about the what we call thalidomicide scandal, the European Court of Human Rights held that Article 10 guarantees not only freedom of the press to inform the public, but also a right of the public to promptly and properly inform. And if you take into account the later decisions also tended to narrowly interpret the scope of the right to freedom of expression as it applies to those who seek information. Therefore, my dear friends, in the case of very, very famous case, and that is the Leander versus Sweden, the applicant complained that his rights had been infringed in circumstances where information about him that was recorded in a register maintained by the Swedish Security Department was disclosed to a potential what we call employer, believing that he had been what we call denied a position on the basis of that very information. And ultimately, in this decision, the applicant, Leander, what we call, sought access to the information in order that he might challenge the decision not to hire him. In considering his complaint that his Article 10 rights had been violated, the court treated the right to receive information as being merely negative in in reality or in as a consequence, and saying the right to freedom to receive information basically prohibits a government from restricting a person from receiving information that others what he call wish or may be willing to impart to him. So that is a very very important what he call diagnosis. And court went on to hold that Article 10 does not, in circumstances such as those of the current what he call case, confer on an individual a right to access to a register containing information on his personal position, or does it embody an obligation on the part of the government to impart such information to the individual? The inclusion by the court of the this kind of a expression that has been taken by the court in circumstances as those of the present case did, however, leave open the possibility that the court might in future find in favor of an applicant to sought access to governmental information. So we will find in the subsequent what you call decision, you will also what you call find in your readings that there is a variation in the decisions. The different lines of arguments have been adopted by various what you call judicial forum or the judicial entities. So whether it is the highest judicial body in a geopolitical entity, whether it is a body which is having the jurisdiction at the first instance, where we find the proper hearing has not been provided to the applicant, but ultimately this right to seek, right to receive, and right to hold opinion has been recognized invariably in all the constitutions as well as the regional, along with the international human rights instrument as one of the most important, unflinching, unwearable, impeachable, important, human right. And there is a unanimity among the jurisdictions on this particular, right. So right to access to information is a very, very important right in the name of certain important, narratives like terrorism, like, national security, and other important, features cannot be denied. This is the right. This is the duty of each and every what we call governmental agency, each and every public authority, each and every international body, international organizations. This particular right has been recognized not only under international law but at the same time within the municipal legal system under the mandate of what we call of international law on human rights. This is a very very important right, and this must under all circumstances be made available to the what we call people who have been seeking information, who are intent to receive any kind of information, and particularly those informations which become important, which are likely to affect the employment opportunities, the dignity, integrity, as well as what we call other important fundamental rights which have been promised not only under international law but at the same time the national constitutions have also granted those very fundamental rights. And this is a grant that comes from the constitution, that does not come from the public authorities or the governments of the day. And you will also find, my dear friends, that the subsequent decisions of the court in the 80s, 90s did, I should say, did not espouse that opinion. However, whether it has been given in any kind of a decision or whether the governments have supplied information in the form in response to the applications where under certain informations, specific informations have been sought, these informations under all circumstances must be supplied to the applicants. Any question?
Sir?
Yeah. Yeah. Please. Yes, Miss Karishma, you want to say something? Yeah, please.
Yes, sir. Yes, sir. Yes, sir. So with in furtherance with the international obligations, that was being incorporated into national constitutions, and was freedom of speech and expression was given to citizens. So I was wondering if freedom of speech and expression to foreign nationals are different in compared to citizens, or is it similar?
Yeah, very good question. Miss Karishma, there is a cardinal principle of law, and that cardinal principle of law established in a magazine which you might have studied, and that is very famous, and that is known as ignorantia juris non excusast. If it is translated into law, I mean in English, it simply stipulates that the ignorance of law cannot be excused. If a Sri Lankan is there in India as a part of the South Asian University, so as a member of an intergovernmental organization to be the valid and duly enrolled, he or she in a position to express themselves. They can claim their entitlements, they can also claim, they can also express themselves. They have the right to receive and seek information. They are capable of holding opinions. They can take into account, they can also bring into notice of the competent authorities about the violations of their rights under international law as well as the national laws of India. But there are certain important conditions, certain important situations, riders, and limitations. And these limitations are also there under the Constitution of Sri Lanka, under the Constitution of Pakistan, under the Constitution of India. Because what is important is that we are, as a nationals of Sri Lanka, as a nationals of Pakistan, nationals of India, or Bangladesh, or Bhutan, or Nepal, or Maldives, we are capable enough under the law to express or to voice our concerns regarding the violations of our fundamental right. And it includes the freedom of speech and expression. But we should not express any kind of, we should not support or we should not participate in those affairs which advocate the radicalization of youth or the radicalization of any kind of a line of argument. We should not participate in terror activities or unlawful activities. And we cannot take the plea that this kind of a protest or this kind of a demonstration which may endanger or imperil the national security, public morality, law and order, and all these things likely to be put in jeopardy, we should avoid these kinds of participations. It is the law of the land that must be respected. Whether we are enjoying the diplomatic immunity or not, but we should avoid all these kinds of involvements. Otherwise, as a citizen of Sri Lanka, as a citizen of India, as a citizen of Pakistan, and currently you are living in India as a student of the intergovernmental educational institution like South Asian University, so you are fully empowered to express yourself. Because limitation should not be taken as some kind of a negative imposition. Limitation should not be taken as a violation of your liberty or my liberty. These limitations are basically of a disciplinary character. These limitations are having some kind of a constitutional requirement of the constitutional nature. And therefore, we should operate our right to express our opinion, our right to seek opinion, our right to receive opinion or receive information. That should be what we call, everything should be operate or must be operated within the framework of what we call constitutional limitations. And there is no harm. Because this is the cardinal principle of each and every domestic legal system, that in case of violations of the law of the land, if somebody is apprehended, then he cannot take the plea that I did not know that it is a violation of law in this country. This plea is not available. That is why I have started with this submission that ignorantia juris non excusus. Otherwise, Constitution of India protects a Pakistani, Constitution of India protects the Sri Lankan, Constitution of India protects the rights of Bangladeshi people, and Constitution of India protects a Maldivian. All your right to life, your right to education, your right to what you call participate and earn a dignified livelihood within India. These are the important what you call rights which are protected under the Constitution of India. And same kind of a liberty and same kind of a constitutional luxury is available to Indians in Pakistan, in Bangladesh, in Sri Lanka, in Nepal, in Bhutan, in Maldives. So these are the rights which are protected under the constitutions of each and every geopolitical entity. Any other observation? Yes, Mr. Sagar.
Sir, I have one doubt. So as you, am I audible?
Yeah, you are audible.
Yeah, so I just want, so after listening to about how right to access to information is so important, do you think that right to access to correct information is more important than right to access to information? Because
Yeah.
right from the state till the, this current situation that we are into from till the pandemic, there is so much amount of information that is available, and every day a new information comes, and it is very, very difficult to segregate the right information from the wrong information. So do we have any criteria that this information is correct and this information is incorrect?
My dear friend, there is a presumption. First of all, let me say, you have really made me happy by asking this question. It's a very, very important question here. First of all, the reason for the happiness is that we are living in an age of, if this is an age of information, this is also an age of misinformation. This is an age of, consumerism, but it is also an age of propaganda. This is an age of the, social media, but this is also an age of unsocial media. So we are having all sorts of, pros and cons. And this social media, internet, ultimately, so far the human relationships are concerned, the social media has made ultimately all the social relationships topsy-turvy. So I sometimes really feel immensely flabbergasted. All kinds of preposterous arguments are there in public domain. All kinds of informations are available. But of course, your question so far, your question is concerned, your question is of vital importance, and that is germane to this jungle of information, where it is immensely has become difficult to sift a needle from the shaft. Why? Because we do not have any kind of criteria to determine the authenticity, veracity. We do not have the proper emplacement of mechanism for the corroboration of information, cross verification of information, or the correct mechanism for the substantiation of the correctness of a particular piece of information. But ultimately, my dear friends, we have to rely upon the governmental information, because whatever the documentation is done, that is done by certain important institutions in private sector as well as in public sector. Because we are also living in an age of the data collection, data documentation. And whatever the data is there, whether it is the a manual documentation, whether it is going to be an algorithmic documentation, we have to rely upon that, because the proper forum are also there. Suppose any information that is supplied by a member of parliament within the precincts of the four wall of a national assembly or the highest legislative establishment, that is popularly known as the parliament in India, or National Assembly in Pakistan, Sansad in Bangladesh, or US Congress is there in US, or the Knesset is there, or other important what we call nomenclatures are also there at international level. If an information is imparted in response to a particular question, so that is the source of information. And the right to information, legislations which have been enacted in the light of the constitutions, as well as in the light of Article 19 of the ICCPR, or Article 10 of the European Convention, or Article 9 of the human rights, African Charter on Human Rights and People's Rights. So whatever the information and bodies are there for supplying of information, we have to rely upon them. And it is a presumption, Mr. Sagar, that whatever the information we get out of or from these bodies or agencies or instrumentalities which have been designated in this direction or in this behalf, we generally believe this information is correct. So that is the only mechanism. And that is also considered to be a primary source of information. But sometimes informations which are supplied by the governmental officials on the condition of anonymity, then these informations cannot be what you call impugned before a court of law. Because what is important on record is that the information should be reduced into black and white. It should be in writing, with the proper seal, with proper signature, with the designation, as well as with the proper department of a particular agency or government or governmental agency. So it is very difficult, my dear friends, because the rumor mongering sometimes is always taken. And since we are living in an age of applications like WhatsApp, the softwares or the social media platforms like Facebook, and these platforms have turned in certain situations as monsters, where the social media platforms even have been instrumental in the regime change. They have created monstrous algorithmic disturbances in a particular geopolitical environment. I can give you an example. Suppose in Vietnam, there were some complaints from the opposition parties, and they accused Facebook that Facebook must what we call unfair criticism of the opposition parties, unfair what we call criticism of some minorities, some ideologies must be removed from its platform. But the Facebook very nakedly and unashamedly denied that if we are going to remove these kinds of posts, it is going to harm our businesses. When information has become a business, then when information has become some kind of a weapon, when information has become an instrument of state repression, then how can we talk in this kind of atmosphere, authenticity, veracity, truthfulness? How we are going to determine the correctness? But what is important, Mr. Sagar, in these circumstances is that these agencies, these social media platforms, or other governmental agencies, they are also supplying, in many situations, politically correct information. And what is politically correct, that you understand. Any other, question, or would you like to supplement on this further, or would you like to enlighten me on this issue further? You can also share your national experiences. National experiences means your own experiences of your own country. You can tell me.
Well, sir, in India, we during the pandemic also, I think it is very funny to be noted, but there was some misinformation that alcohol is good for this COVID, and people, and there is a little bit of amount of alcohol in sanitizer, and people started drinking sanitizer, and there were a lot of deaths in India, if you have heard about it. I mean, there is so much of misinformation about these things, and these are very, very
Yes, even
critical
this
issues.
information, this is important.
Yeah,
This
sorry.
is important. That is why I am saying that the information which is supplied by the governmental agencies and governmental bodies constitute a very, very important, segment of information. So that ensures the truthfulness and the reliability of that very information. There is a, information from the political mouths in India that there has not been any kind of a, paucity of oxygen cylinder during the, peak days of, global pandemic. There has not been any kind of a death due to the what we call, paucity or the lack of, or non-availability of the gas cylinder in India. So who would verify it? Videos are there, video recordings are there, all kinds of, information is there, but information must be what we call, seconded. Information must be appropriated by the competent authority, but who will approbate it? Who will approve it? Who will notify that very information? Recently, the WHO has also, pointed out that there has been as many as what we call, 40 lakhs deaths in India because of the global pandemic. But that is being disputed by the government. So who will approbate it? So we have to have some kind of a, mechanism, some kind of a national authority on this particular, point. We have to have some kind of a, mechanism. At the same time, we should, because right now we have been relying on the what we call, right to information legislation. And the authorities which have been designated under this particular piece of legislation are competent enough to issue information. But there is one, clause in the right to information legislation on right to information law in India, and that is Section 8. And in the name of, national security, in the name of, national integrity, or in the name of the classified information that cannot be divulged in the public domain, such kind of an information is generally denied. So these are some of the important implications. And that is why, my dear friends, this is the, area of further research. And it requires some kind of a, empirical research. So it is very difficult. Whatever I am saying, tomorrow the government may be of the view that whatever we have been, deliberating, that is not the, scenario, that is not the, situation. So the seeking and receiving correct information is $1 million question. That creates a catch-22 situation. So how to have this kind of a, clarity, transparency, how to come out, how to, dismantle this smoke screen when there is a question of, correct information. This is the requirement of the transparent governance. Therefore, it is the, state obligation, my dear friends. And state obligation is only limited to impart those very information which are, held by the state under its, records. And whatever is record, and who has, prepared that very record. Otherwise, if you can, we are living in an information age, as I have, submitted, but at the same time, we are also living in a misinformation age. Without any kind of a verification, without any kind of a corroboration, what we generally receive on WhatsApp, particularly during communal rights, all kinds of the humor mongering is there. We have created in India, in South Asia, lot of a kind of a miasma of myths against different communities. Socialization, cross-fertilization of social relationships in different communities or with different communities have come to an standstill in South Asia. So, right to receive, right to hold, right to seek information, my dear friend, is important. But right to receive correct information, right to seek correct information, and right to hold correct opinion is equally important. You cannot hold a wrong opinion about anybody. You cannot receive a wrong information about anybody or about any program, about any scheme, governmental funding. We cannot receive or seek a wrong information. So first of all, we should also introspect ourselves whether we are seeking or receiving or holding correct information, correct opinion, correct facts. That is equally important. It is our fundamental obligation and fundamental duty as a law-abiding citizen of any geopolitical entity that we should be able to seek correct information from the governmental agencies. It is equally important. Yes, Miss Vinita. Yes, ma'am.
Sir, good morning, sir.
Good morning,
Sorry.
ma'am.
Yes. Sir, I have a question. I don't know whether it is appropriate or not,
Everything
but
is appropriate whenever anything is asked by the students. Because you are enjoying the luxury of what you call of asking questions. Even the wrong questions is a luxury if you are asking. This luxury would not be available to you when you are going to be enrolled as a research scholar, as a student of PhD. But as long as you are doing your LLM, you are free to ask any question. Please go ahead.
thank you, sir. Sir, as we hear that our media, that is, I mean, Indian media is working as Godi media, or we can say puppet of government. Who is responsible? Why our media is working as Godi media? Our constitutional framework is actually responsible where we are actually lacking. Why our media is working as Godi media? That is my question.
Ma'am, the correct translation, it's a beautiful question, relevant and contemporary question. Godi media means embedded media, pliant media, docile media, a media that believes in the doctrine of his master voice. That sort of media is known as Godi media. Again, the question that has been posed by Mr. Sagar Verma becomes germane, relevant. You are asking, you are branding channel A, newspaper A, social media A as Godi media. But the same another person is also branding whom you consider as the correct media, as the real media or mainstream media, as Godi media. So we cannot have a class of scholars and experts categorizing a particular channel or a group of channels as Godi media, and there is another class, there is another group of journalists, they are also branding those very channels who claim themselves as the real media as Godi media. It is vice versa. It is a question of the democratic values, constitutional values, because we have to test which particular channel, print or what you call internet channel, audio video channels, which particular channel should be considered as embedded what you call channel, or the governmental client channel, that has to be tested on the basis of the constitutional conventions and constitutional norms and values. Because there is a requirement of the constitutional trust and constitutional morality as one of the most important criteria to determine and to measure embeddedness, entrenchment, entanglement, and the pliancy and docility of these kinds of media houses or the media channels. So we do not have any kind of a yardstick. What is important is there should not be any kind of a manufacturing of issues. There should not be any kind of a cooked up, doctored issues. There should not be any kind of a clamoring or noise on the channel. What is important is the real issues. And the real issues should always be what we call garnered from the idea of constitutional governance, good governance, transparent governance, democratic governance, accountable governance. In each and every constitution of the South Asia, Miss Vinita, our issues have also been incorporated. If you take into account principles of governance or instruments of governance, principles and policies of governance part, which is known as in India as directive principles of state policy, which is known as under the constitution of Nepal as the directive principles of state policies and responsibilities, which is known as under the constitution of Bangladesh as principles of policies of what we call of governance. If you take into account these parts are nothing but the historical documentation of those very situations which ultimately colonized our entities, identities, geopolitical entities. So since you are from India, I can give you an example from the part 4th of the Constitution of India. It has been realized by the Constituent Assembly in 1946 when the Constitution was completed and adopted on 26th of November in 1949. And all the issues and challenges which have been identified by the members of the Constituent Assembly of India have been placed in the form of articles, non-justiciable articles under the part 4th of the Constitution of India, which is known as Directive Principles of State Policies. So we know the issues. We know the challenges. Challenges have been incorporated in the preamble to the Constitution of India. So we have to attain, we have to realize, we have to make available these goals and dreams to the general public, and that is the public of it. But what I have been witnessing in South Asia and beyond South Asia, all the republics have become away from public. So these are the issues, challenges, goals. Directive principles of state policies of each and every constitution, whatever may be the nomenclature, whatever may be the expression, whatever may be the title of those very chapters, must be equated with the Sustainable Development Goal Agenda of 2030. So we, as a what you call, citizen of India, you as a citizen of what you call of Pakistan, as a citizen of Bangladesh, as a citizen of Sri Lanka, has got the right to ask our respective governments to what extent the constitutional provisions of this part, specific part, have been implemented. Are we asking? Are we citizens, democratic citizens? Are we sovereign citizens? This is the, very, very important question. Constitution never fails. Constitutions never fail. We, the people of a particular geopolitical entity, fail our constitutions. Otherwise, everything is, there. State shall achieve this, state shall endeavor for this, state will secure this, state will strive for this. Every kind of a, terminology is there for every kind of a, issue. Preamble is the most important part of any constitution. The very first duty of the government and the citizens collectively begin with the preamble to the constitution. What kind of an oath is generally administered to the member of parliaments and ministers? See the content of that very oath. And see, equate, compare the contents of the oath, which is administered to the member of National Assembly or the Parliament or state or provincial assemblies, and try to, whether it is a federation, unitary, whatever may be the nature of the country or constitution, see the content and compare those content with the conduct of that very member when he performs his public duties in public domain. So, my dear friends, it is very, very important, because remember one thing, when we are talking of right to seek information, it is the DNA of each and every government. And it's an absolute submission on my part that the national governments of any geopolitical entity, governments have always been in the habit of denying information. Government generally, invariably resist imparting information. It is the manifestation of the state behavior, but at the same time, it is the beauty of the ordinary citizens. A well-informed citizen, a democratic citizen, that they must seek information in the most viable manner. This is the idea. This reminds me of a very, very important decision. This is a decision, or in the case of the Gaskin versus United Kingdom, court was of the view that Article 10 of the European Convention did not embody an obligation on the state concerned to impart to the applicant information contained in records. And the records are maintained by the public authority, and that too relating to a time when he had been in public foster care. When I was performing my duties as an associate proctor, as an assistant proctor in Aligarh Muslim University, my previous what you call a parent institution. So one application I have received, because I was the designated authority under the right to information legislation in proctor office. So my dear friends, the information that was sought by one of the students was how many cup of teas I generally take on daily basis in proctor office. So I immediately, because of the nature of question, I still remember that very application of a student. Instead of what you call, giving an answer within a month, I immediately contacted that very student and invited over a cup of tea in the proctor office. I invited him. And I wanted to understand what exactly has been the rationale. There were, some portfolios with me, and one of the portfolio was relating to student discipline. So I issued some show cause notices to students. And it has been the practice of the proctor office. They generally, after, issuance of the, show cause notices to some of the students because of their, unruly behavior, the charge sheet and the charges were never supplied to them. I started this very practice. No. First of all, I have studied entire what we call, right to information legislation in India. And thereafter I decided, and I reduced it into black and white and issued instructions to my subordinate staff in the proctor office, and I requested them that please, whenever any show cause notice is issued to the student, and the entire complaint, content of complaints, accompanying evidences, charges, everything should also be supplied with the show cause notice, so that the student should be able to frame properly his entire defense. He must be given this opportunity. So I started this practice as a student of, international law, as a student of, because at the same time, I was having another portfolio advisor to the international students. Because in AMU, there are as many as more than 30 nationalities. Some of the students in the evening used to approach me at my residence in the campus of Aligarh Muslim University. And they wanted my views, what kind of a defense should be prepared. So in the first half of the day, I used to issue show cause notice. And in the evening, if any student approached me, I assisted him to prepare his defense, counter what he call, arguments. That this is something that very funny and very ironical. So we should not seek a frivolous information. We should not who supplies petrol to my scooter as an assistant proctor, as an associate proctor. Another application was there. Because by asking certain information, even the ordinary citizens who try to harass governmental agencies and governmental officials. So if we are intending to seek proper information or the correct information, then it is our responsibility to seek only relevant and correct information. No vexatious, frivolous, and baseless what we call, or the rumor mongering induced information be sought. That should not be sought. So that has been the working of the various what we call agencies and various institutions. The correct information should be supplied. So it is the responsibility of an informed citizenship. This is the duty of an accountable what we call citizenship. It is the fundamental obligation on the part of well-educated citizenship that they should seek correct information, viable information, and information which is in the public interest, while maintaining the obligations emanating from constitutional trust, constitutional morality, public order, fair play, equity, justice, and reasonability. This should be taken together. And that is why, my dear friends, in Guerra versus Italy, the court reiterated its view that the right to freedom to receive information under Article 10 basically prohibits a government from restricting a person from receiving information that others my dear friends, wish or may be willing to impart to him. Court was of the view in this particular decision, and that is very much relevant, and immediately I recalled it, that the freedom to receive information as it has been referred under Article 10 of the convention cannot be construed as imposing on a state in circumstances which have been what we call enumerated in the application. Because what is important is, it is the beauty of the positive obligations to collect and disseminate information. The decision in this particular decision, therefore, in this particular case, not only confirmed the court's reluctance to allow Article 10 to ground the establishment of a right of access to official information, but also restated its opposition to the use of Article 10 to impose positive information dissemination obligation on the state. So therefore, what is important is the pivotal issue that there has to be the establishment of a right to freedom of information under the umbrella of the right to freedom of expression that has been guaranteed under the law. So vexatious information, frivolous information, unfounded information, baseless information, or derogatory information, and the information that violates and infringes the right to privacy should not be asked. If we are really interested to establish ourselves as the rightful what we call or rather I should say law-abiding citizens, if we allow ourselves to be addressed as the citizens who believes in pluralism, multiculturalism, diversity, and the constitutional values and constitutional conventions, then we should be very careful, because as you have raised this particular issue of the correct information, then we have the right to ask for, to go for, or to receive correct information, but we have to make, in our application, we should also seek correct information. So thank you very much. I will continue. And meanwhile, I will also supply a requisite material, whatever I have deliberated today. Thank you very much.
Thank you, sir.
You're welcome.
Thank you, sir.
Thank you very much.